This is Paul. Yes. Just mentioning that cell hearing. You're detaining me in a mental institution? Yes. Well, I don't think there's any professional process server would have served the criminal complaint without the underlying judge's signature. Now I'm going to sue them as an industry that I'm going to want to know the actual ownership of all of those that have hired a professional process server. Yes. Where they would have looked at it and said, well, where's her signature at? Pooh. Why does it say that he didn't get any notice or opportunity to be heard? Yes. That the respondent didn't receive actual notice of the hearing? Yes. Why is it that the signatures are different of the ex officio superior court clerk? Yes. This signature is not the same as this signature. Yes. Now, I think that for any professional process server to serve any service or process without an actual signature of the petitioner, acknowledging receipt of a copy of this order that was necessary to use the social security number of both the respondent and the petitioner, yes, I think they'd be personally liable for serving a process, yes, where it was not valid. Now, process servers probably go through some sort of educating, yes. And then there's the criminal complaint of Jefferson County where there is no. Ooh, ooh, ooh. Now we're going to have a cell hearing on January 4th, and you're going to detain me in a mental institution? But a sufficiently coercive order requiring an individual to leave his own home counts as seizure subject to the protestations of the Fourth Amendment. I thought it was coercive on the part of the court. Yes, to issue any court orders without the protections of law. Yeah, put my name right here. A report of domestic argument standing alone does not demonstrate exigent circumstances. Now, there was actually no physical abuse to Heidi per se. Pooch. We did have an argument on July 2nd of 2011 where she wanted to spend half the welfare to go buy new clothes for my sons. Hell. Thus, officers responding to a reported domestic dispute must point to something beyond the mere fact of an argument to demonstrate an objectively reasonable basis to believe that there's an immediate need to protect the lives or safety of themselves or others. Now, obviously, the issuance of protection orders never has exigency, yes, circumstance, because judges don't decide that, officers do. Now, unlawfully seizing myself as a plaintiff when he complied with the order to exit his house with officer with no probable cause. Nothing indicated that I had done anything wrong, and I did not possess any credible threat to the officers. Yes, you didn't have to sneak up on me. You could have just said, Paul, we'd like to put you back in the car, okay? Apples to apples. And when that morning, yes, where you decided to transport me across county lines, I had coffee and water in both hands so that I could not. Ooh. Now, we also found the law on this point was clearly established, making qualified immunity inapplicable. There is no qualified immunity for any cop in any police station of the United States, yes, that has any knowledge of these arrests, that have alleged crimes, yes, where there was no probable cause, yeah, because of the issuance of fraudulent protection orders. Poop. Okay. Now, there was a letter dated September 25th, 1944, punishment of war criminals. Now, the Judge Advocate General established an office agency under his direction which would collect the evidence of the cruelty of depriving American citizens of their rights and allowing for the kidnapping of their children. Yes, the atrocities of having me put in prison and then having me go to a cell hearing. Yes, where you're going to detain me in a mental institution without valid criminal complaints. Yes, and then the acts of oppression against myself because of your refusal right now. I think there is some real evidence that the judge advocate generals could establish an office where they find out, yes, that police departments and sheriff's departments are committing the crimes of cruelties and atrocities and acts of oppressions against other Americans, those known as myself and my family, that don't happen to be members of our armed forces. Now, examine and sift through such evidence. Yes, after 40 or 50,000 emails to CID about forgery and fraud, yes, misrepresentation, welfare fraud, Social Security fraud, Labor Department fraud, the abusive use of background checks, the obstructing, apprehension and prompt trial of person against whom a prima facie case was made out. Now, I'd seen prima facie case before from the deputy prosecuting attorney, Brett Roberts. Yes, yes, yes. I thought in his response he said something about the prima facie case. Yes, the face of it. Now, I know Phyllis did her mental health evaluation and had a talk with Jack when I wasn't in the room, where Jack completely disregarded everything I said during the interview. Yes, because I noticed that most of the changes to what was said happened when she had a visit with Jack when I wasn't there. Yes. See, it says here, right. Let's see here. Coach reported, so on and so forth. Yeah. Falsity mini mental evaluation. Now, newest charges were an understood class of instruction. Convinced I asked Mr. thought he was treated fairly by the court. Now, a discussion with my public defender, the evaluation, not an attorney, and expected. I need to clarify some of Mr. Budnick's statements without Mr. Budnick being there. Ooch, Jack Range, yeah. There are violations of the women's protection orders are occasionally served. The court has had a chance to sign. Yeah. No, no, no. Now, on the prima facie, okay. Let's see here. Brett Roberts, yes, yes, yes. Will address and delay unnecessary renewed competent questions resolved. Yes. Antipsychotic medication. Yeah. Let's see here. Hearing said over. Yeah. Maybe it was page 3. Oh, here it is. Order angry was issued. No, from rather evidence established. Prima facie case. Oh, the Mr. Budnick had knowledge of the order. Ooch. Just like the prima facie case of the Department of Defense right now. I think the Judge Advocate General can involve themselves, and I think that the Criminal Investigative Division, yes, of the Department of Defense in each branch of the military does have the legal right to involve themselves. Now, I know the Posse Comitatus Act and related matters is the use of the military to execute civilian law. Now, I looked through this. I'm kind of jumping ahead a little bit because of time constraints. Yes, but there are certain exceptions to that, and I'm going to jump ahead. I'm going to jump back in just a second. Yeah. Let's see. Posse Comitatus Act 18 U.S. Code Section 1385. Was to end the use of federal troops to police state elections, Confederate states, so on and so forth. Yes. But key exceptions to the Posse Comitatus Act. Yes. Under state rather than federal service, National Guard forces operating under the state authority of Title 32. Yeah. Presidential power to quell domestic violence. Oh, oh, oh. Presidential considers impractical force of laws of the United States. Interpretation policy. Oh, look at use a member of the Judge Advocate Corps as a special assistant prosecutor while retaining his or her dual role and participating in the investigation, presentation to the grand jury, and prosecution. Did not violate Posse Comitatus Act. Oh. The Coast Guard is exempt from the Posse Comitatus Act. Yes. Now, I interpret this exemption from the Posse Comitatus Act, yes, is that the Judge Advocate Corps and all the attorneys that are employed in that, which, as well as CID investigating criminal activity, I can actually sue the Department of Defense